welcome you to this dinner, and those of you, and I think all of you, were here to hear Justice Ginsburg's remarks this evening, and just get a small picture of the high degree of excitement she brought to the law school today, visiting classes and students anxious to ask her every question they could think of, although she repeatedly told them that she couldn't comment on matters that might be coming before the Supreme Court. They still tried, but unsuccessfully. Justice Ginsburg declined to have any press interviews, but she made one exception today. She was interviewed by two 9-year-old reporters for the kids page in Newsday. And it was conducted right in the corner of the room, and the reporters had their questions written out and shaking while they asked their questions, but it was a very nice interview. While we were in the auditorium, Dr. Lander, the president of Touro, arrived, and I'd like to introduce him to you. Dr. Lander is not only the president of Touro, but he's also the founder of Touro. Dr. Lander founded Touro in 1980. At that time, 1970. At that time, he was the Dean of Graduate Studies at Yeshiva University and also a tenured professor at Hunter College, a very prominent sociologist, and in the days when he had time to be a scholar, he did some very scholarly research, and he was also appointed by Mayor LaGuardia to what was probably the first Human Relations Commission in the United States back in the 1930s. I'm very pleased to present to you Dr. Bernard Lander.
I'm honored to be here tonight, together with our distinguished guest and her husband, and members of the family, the Ginsburg family, who are the founders of Touro College, and Jack Ginsburg, as you know, was a father of our law school. In a sense, the presence and participation of Judge Ginsburg as a untenured visiting professor at our law school prefigures the concept that is being advanced by Touro of a new type of complex. Judge Ginsburg's presence here represents the symbiosis between those who make the law and those who teach the law, theory and practice. And what our brilliant dean is trying to achieve is to build in Islip a campus which will include, I believe for the first time in the United States, a school of law, a federal courthouse, a state courthouse, so that the student moving out of the classroom goes into the corridors of the Supreme Court or the state court. We will be hopefully training members of the court system of the state of New York, and we hope to achieve this kind of integration between those who study law and those who interpret law. It's a great idea, and this week is in a sense a dress rehearsal for this conceptualization, which we hope will soon become a reality. I would like tonight, as I said to Justice Ginsburg with her approval, to expatiate on her comments. One of the fundamental themes of her wonderful address to us was the theme of justice shall thou pursue. And in the examination of the text, in its original Hebrew, one finds a mistranslation of the Hebrew into the English. 2 weeks ago, we read the portion in which this verse is included in the synagogue. And And the portion of the Bible starts, judges and a system of justice shalt thou establish. Verse 1. Verse 3, tzedek, tzedek tildov. Righteousness, righteousness shalt thou pursue. Justice is not always right. The Nuremberg laws were laws, but they were not just laws or laws representing human decency. The laws in Stalin Russia were laws. There was a legal system to the extent. But they represented justice as they interpreted it, but not tzedek, righteousness, decency. And it's beautifully expressed in the conclusion of the portion of the week. The Bible tells a story of an individual who's found murdered between two cities. And the Bible tells us that's the responsibility of the elders of the city to measure the distance between the corpse and those two adjoining cities. And the elders then, upon identifying the city closest to the corpse, are obligated to bring a sin offering, a red heifer. And the rabbis in the Talmud ask, as repeat the question asked in the Bible, does one expect that these elders kill this individual? Why must they bring this sin offering? What was their sin? And as they bring this sin offering, they repeat the biblical phrase, Yodenu lo shafras adam hazeh. Our hands did not cause this person to die. Einenu lo, we did not see. And the answer is a very simple one. They may not be guilty in a court of law, but it may have happened that this individual who was murdered came to the village and asked for shelter, and nobody was there to open his door. He may have come for employment, and nobody there is there to give him a job. He may have come for food, and nobody was there to help him. And so, even though, from the point of view of the law of man, they are not guilty, but from the point of view of the law of God, they are as guilty as if they had murdered that individual. And so the Bible attempts to draw a very important distinction between justice, which is law, normative law, and righteousness, which is something which supervenes merely the code of man. And in a sense, this is what Maimonides meant when he spoke of the 10 rungs in the ladder of charity. The lowest form of charity is when a man comes and asks for help, you give to him. A higher, more elevated expression of charity, of tzedek, righteousness, is if there's no direct contact between the beggar and the donor. The highest form of tzedek, of righteousness, is the building of a society that prevents poverty and prevents the need for people to come and to beg for help. And may I just conclude this simple thought. There's a very beautiful midrashic comment that when the brothers of Esau finally were summoned to the land of Egypt to save the brother and later on to find the father alive and to be reunited as a family, the comment is, what were they doing? What were they talking about? And this comment of the Midrash says very beautifully, they were discussing the story of the Red Heifer. Now what is this mystifying comment? There was a debate between the brothers. Were they guilty or not for the brother being in Egypt? One group said, we're not guilty. We didn't sell him to the Ishmaelites. We didn't destroy him. We didn't make of him a slave. We're not responsible. We left him alone. We didn't help him. From a point of view of law, of man's law, we did nothing to harm him. We just didn't help him. left them in the hot sun. But then the predominant point of view, there's a distinction between merely pursuing justice and pursuing righteousness. Frequently, in the court of law, an individual or a society may not be culpable, but from the point of view of decency, of human decency, they may be guilty and sinful. And from the point of view of the Jewish heritage, the purpose of man is not only to pursue justice, but to pursue, as the biblical expression was, Sisa HaYoshabato, to do that which is right and that which is decent. And one more postscript. Philo, the great Alexandrian philosopher, who lived 1,1300 years ago, also makes a fascinating comment on the very same post. Why the repetition? Tzedek, tzedek, justice, justice, righteousness, righteousness. And he explained, there are many times individuals or even societies present noble ideals. The Greeks had noble ideals of equality, of liberty. The Republic is a paean, a poetic expression of some of these noble ideals. Communism in its early days, every man according to his need, the equality of man. But what is important, said Philo, to remember, that the ideal must be noble and just, but the means must be equally holy and pure. And so what is important is not only what you espouse, but the means and procedures you utilize in achieving those noble or beautiful ideals. Touro Law School is dedicated under the leadership of our faculty to help the poor. Our clinic is outstanding for its activity. We believe in the liberal credo. We believe in the liberal tradition. And we hope under the leadership of our outstanding faculty, and of course with the inspiration of Judge Ginsburg, that in her life and in her writings reflects and intellectualizes these great ideals, we shall be noted not only to pursue justice, but to pursue decency and righteousness.
Although I don't see any 11-year-olds in the room, as far as I can tell, Justice Ginsburg has nevertheless agreed that she will answer some questions. So if you'd like to address some questions to Justice Ginsburg, and she can differ with Dr. Lander, file a concurring or dissenting opinion. Who would like to ask a question? I can bring the microphone over, so. Who would like to ask a question? Do it.
Justice Ginsburg, are you affording Susan B. Anthony dollars, or how is your relationship with Justice?
He's a marvelously efficient chief. You know, we are about to have our first conference on September 29th. We will consider all the cert petitions that have accumulated since we left town. My colleagues tell me that in the days of Chief Justice Berger, those conferences ran on 3, 4, sometimes even 5 days. Our current chief has us convene 9:30 sharp, and we are out by 5:30. At least that has been true of the 4 years that I've been there. He's a very effective chief. What do I think about my chief when he's a man who writes thinks his hobby is writing. He did vote on the other side of every case but one that I argued. But then he cast his vote for my judgment, if not my opinion, in the BMI case. So he has learned. I
Questions, comments?
Judge, I've heard for the last year or so that they've had a problem filling the federal judiciary. There's a lot of openings that I've read a lot that there's a tremendous backlog in the federal cases. And I just want your opinion as to how to break the logjam in terms of handling the federal cases because of unfortunately, the amount of judges that are not being replaced in the judiciaries.
Well, at first, it was a problem both with the executive and the legislature because there weren't enough nominees. Now I think that problem has been largely cured, but only in very recent weeks. There's a natural tendency when one party is in control of the legislature and a different party in the administration to resist nominees, looking to the day when the other party may control the White House. Now that's something the Democrats did with respect to Republican appointees at the end of the Bush years, and it's something that the Republicans may be attempting now, although it's early days, it's at the beginning of Clinton's second term. Nevertheless, I'm going to quote next week when I talk to the National Association of Women Judges in Salt Lake City, the words of Orrin Hatch, who is the chairman of the Senate Judiciary Committee, about how much a strong federal judiciary means to him. They're moving words. They're words I could have written. I think he's proud that he said them and is trying hard to keep the federal courts what they have been and should be in U.S. society.
Right.
In choosing where you will speak and where you will go when you're not performing official duties, and you get, I assume, many invitations, do you have any basic philosophy or concept that you employ deciding which invitations to accept and which not to accept?
Mostly, if people I really care about ask me to come, and ask me not just my dean asked me to write you a letter to come, but you would. I know you get a lot of invitations. You will be doing something very good if you come here. So in this case, it's very clear I'm here because Jeffrey Morris urged me to come.
For those of you who don't know, Jeffrey Morris is a member of our faculty. In addition to an excellent law professor, he's also a prominent historian.
You asked for statements as well as questions. I think the statement I would like to make is that it's a great source of pride and pleasure to every one of us sitting here who have watched and read what Justice Ginsburg has written and declared, but more important, what Justice Ginsburg really is. Reflects great credit on all of us here tonight.
Tell Marty to tell my children.
I think Fred was looking for guidance about which invitations he should accept.
Actually, as being new to this wonderful system was wonderful because I had a sense of some detachment. I feel a little different in year 3 than I did when I was last teaching at Touro. And you just wonder what is appropriate, what's not appropriate, and how one balances all these public aspects that they create.
The first rule is the court comes first, so I never accept an invitation during a sitting period because I'm spending all of my time concentrating on the business of the court. I must get a zillion graduation, we want to give you an honorary degree, I could have so many honorary degrees. But that usually comes along with, and yes, what you give, the commencement address. But those I turned down. I didn't my first year, and I didn't know what May and June were like. I was a little bit like your first child. You really don't know what it is till it happens. And that first year, I was staying up literally around the clock. So I vowed that in graduation season, henceforth I would stay home. But that is the first rule. When you have the coursework to do, you don't go elsewhere. So next week, when I go to the National Association of Women Judges, that's going to be it for a while. I'll be in D.C. until we have our first break. And then I'm going to the University of Hawaii to be there visiting.
That gives you some standards. Other questions? Oh, I'm sorry. Howard?
I hope this doesn't sound personal, but did you ever aspire or think that you would be a Supreme Court justice, or when you kind of sit around and maybe look from the outside in, what do you think about being a Supreme Court justice?
I think it's the best job in the world for a lawyer. Did I aspire to that job? When I graduated from law school, I told the students, there was not a single woman on the appellate bench of any federal court. There had been one appointed in the history of the United States, Florence Allen from Ohio. When she retired, there were none until '61, when President Johnson named Shirley Hofstetter to the Court of Appeals for the Ninth Circuit. So when there is one in the entire country on an intermediate appellate court, to say nothing of the Supreme Court, it is not a job that to which you realistically aspire. I just hoped that I could get a job to do rewarding work in the law, and I never thought about being on any bench until Carter's administration, when Carter looked in places where people never looked before for judicial nominees. And as a result of his search, the federal courts, I think, have never had more talent in history than they have at this time. There's a letter that I sometimes quote from a great abolitionist and feminist from the middle of the 19th century, Sarah Grimke. She's describing to her friends her visit to Washington, D.C. And she writes in the letter, one day visited the Supreme Court, not in session, was shown the bench, took the Chief Justice's seat, and said, who knows, someday a woman may occupy this position. And next line, and the brethren laughed heartily, but it may be a true prophecy. Now that doesn't seem at all outlandish today. There is still a tendency to confuse Justice O'Connor and me. And last term, our Solicitor General, acting Solicitor General, a law professor, Walter Dellinger, 3 times called me Justice O'Connor. Not that we look alike at all. But she was there all along for 12 years, so the woman is O'Connor. The cabinet makers and woodworkers and repair people of the Supreme Court had greater vision, because in the weeks before I came, they did a repair job on a rush basis, and it was to install in our robing room a women's bathroom equal in size. So no, the answer to your question is that it wasn't in my wildest dreams. But my granddaughter last week, when she was with Smith and was asked what she would like to be when she grows up, she said, well, president, or maybe vice president.
Other questions? What, Brad?
Justice Ginsburg, I have a two-part question. First being, can you give us a day of the life that you lead while the court is in session? What is your day like? The second question is, do you keep a personal diary? And I know that you have the ability to as a justice, to take your notes and records with you or publish or to give them to an institution. Have you made a decision on what will happen to your papers?
To start with the last question first, no, I haven't made that decision. Most of the justices have arranged for their papers to be with the Library of Congress. And I haven't decided either whether my papers should be available immediately, as Justice Marshall's are, or after an interval, the time suggested by some people as until the death of every justice who sat with me. Could be a rather long time. What is the day like? Let me describe the first Monday in October and all the days of that week. The court is hearing 3 cases each of those Monday, Tuesday, Wednesday, so we will meet in the robing room, shake hands with each other, go on the bench, quit exactly at noon, no matter where we are in the argument, have lunch together, come back on the bench. When the arguments are finished, I will go back to my chambers, talk to my law clerks about the arguments, check a few points from the arguments I just heard, and go on to tomorrow to check over. I will by then have read all the briefs and all the cases of the city. But can you hear me?
No.
To prepare for the next day. That's a very intense 2 weeks. We have Thursday off, not off from work, but off from the togetherness that finds us the rest of the week. On Friday, we meet to confer on both the cases that were heard on Tuesday and Wednesday. Wednesday afternoon, we confer on Monday cases. Friday, we confer on Tuesday and Wednesday cases, plus all the cert petitions that have accumulated in the meantime, and have lunch together again. So there's not much space for anything but being with my colleagues and working in the 2 weeks that the court is sitting. 2 weeks off, I am both doing my homework, writing the opinion in the case that was assigned to me, or opinions, and gearing up for the next set of hearings. So that's the working life at the court. There are diversions, and some of them are wonderful. I'll just give the example of the State of the Union evening dinner. The court gets up when the president comes in and applauds. Then we sit down. We do not bob up and down like the rest of the crowd does. We just sit there, sober as judges, and then we stand and applaud again when the president is done. To fortify us for that experience, we have a dinner at the court. And this year it was co-catered by Mary Kennedy and Ginsburg. And the dinner and the wine, it was so good that I had to station the men on my left and right. I just happened that Farris Thomas is on my right and Steve Breyer on my left. And I said, when I look like I'm falling asleep, please pinch me. So we also celebrate joyous occasions, like Justice Scalia's daughter number 3 had her wedding reception at the court on Columbus Day last year. Oh, and my granddaughter's 3rd birthday party. That's the court. Anything else you think I should add about life at the court? We work hard. He'll vouch for that. Oh, I should tell you this because it's a very important part of my day, every day. Telephone starts to ring at 7 o'clock, and Marty said, I have to come home for dinner, but I have to finish reading this brief. Then he calls at 7:30. Why haven't you left? Because there's another case I'd like to check. And we go on and on like that.
I usually don't call till 8:30.
He does. I was based out of the kitchen 18 years ago. And that's why my chambers are so popular, because Marty makes dinners for the law firm. So we're having and he makes cakes for my tea. The law clerks from other chambers, to get to know the justices, they invite us to lunch. Well, that lunch is not my big meal of the day, so I invite the clerks from the other chambers, one set at a time, to my chambers for tea. And Marty, this time made, what was it, a sour cream cake? Which he served with wonderful white peaches. And there was the one that was for Stephen's clerk. The chief clerk, he made a chocolate loaf. And I don't know what you're making for O'Connor's clerks that are coming this Wednesday.
Tell me.
Yes?
Could you tell us to what institution your husband will donate his recipes?
Well, it's hard you can.
Like you, I haven't thought about it.
How are the opinions assigned to the various justices?
By the chief's magic. Now, none of us know what his formula is, but on the Monday after a sitting period, he will circulate a list of assignments. He tries to do it so that the load is spread out more or less evenly. It's hard to know what his standards are, except for one, which he tells you and he follows through on. If you are behind, that is, if you have a couple of opinions assigned and you haven't got the draft in circulation, you can be sure that you will get whatever is the most dreadful assignment the next time. He also gives us deadlines, and not a single justice has gone over the deadline in the 4 years I've been there. One is every majority opinion must be in circulation by June 1, every dissent by June 15. So the rest of us can have a chance to respond in a separate opinion, suggest changes, and the rest. I remember a couple of times when David Studer and I were there past 11 in the evening, and we hadn't gotten the last either court opinion or dissent circulated, but we both had them date sent before midnight. So he's a very effective chief that way. Now, when he isn't in the majority, the most senior justice in the majority will make the assignment. We'll usually make that the Friday before, and then the chief will put it on the list. But I think the troops are fairly content with the way he does it. He doesn't do it by specialty. There's no more likelihood that Steve Breyer will get an antitrust case than I will, for example, or that I will get a procedure case than, say, Clarence Thomas will. So we're not allowed to be specialists.
final question? Okay, Justice Ginsburg?
How much, can you give us a sense of how much informal discussion or consultation there is among 2 or 3 of the justices while these majority opinions and dissenting opinions are in circulation?
There is quite a lot. There's considerably more than there was when I was on the DC Circuit. I have met with some of my colleagues to iron out a dissent, to have 4 people on board for a single dissent rather than have 3 people go off in separate ways. There's a lot of adjustment. Some of it is done in writing through memoranda, but a lot of it is also done face-to-face. So there's a lot of collegiality. Really, that's something that I found surprising and heartening, that the justices really do take the idea of the opinion of the court seriously. So there were many decisions where significant changes were made on the basis of post-argument discussion.
Justice Ginsburg is having breakfast tomorrow morning with our student leaders, so I think we should let her finish her dessert and relax for the rest of the evening.